Very good evening to all of you. Uh, Good evening and I welcome today's speaker Kamal Garg sir and our Hyderabad branch chairman Deepak Ladda sir for this wonderful special topic on arrests under the Companies Act 2013, a very unique and peculiar topic for all chartered accountants. For this, we have one of the greatest speaker of the country, Kamal Garg sir, who is a chartered accountant and a lawyer, advocate himself. So now I request Deepak Ladda sir, Chairman sir, to give his welcome address.
Thank you, Secretary Ramesh. Respected Speaker of the day, Kamal sir, and the audience.
Sir, आपका voice कम आ रहा है.
Was already joined by this time. A warm festival greetings to all of you, and I welcome you on this important topic of arrest under Companies Act.
Chairman sir, थोड़ा voice बढ़ाना.
Okay, I welcome you on to this topic on the arrest under Companies Act. The reason we selected this topic from Kamal sir is because of the vast.
Chairman sir, still little voice is not heard properly.
Okay. Is it now better?
No, not enough. Thoda out thoda.
Good evening, all.
Yes.
Yeah, sir. The reason why we selected this topic from the Kamal sir was because of the vast experience and the subject knowledge on the command. Sir has, and when I was in touch with sir 2 weeks ago, sir gave me 4 or 5 topics and asked me to select this one of the topic about this. And I've seen the sir profile on Facebook and LinkedIn, and sir taken over this topic, so I find it very particular interested. Because many chartered accountants and the director, as we advise many clients on this on various provisions of the Companies Act, and sometimes we restrict ourselves only on the penalty provisions. So there are certain serious offences under the Companies Act which requires arrests from the onto the directors and the promoters. So it is very much important that apart from the penalty provision, we also know the prosecution provisions, so that we are much aware of this and can advise our clients on a right perspective. And similarly, from auditor point of view, we should always know the worst case scenario, as it will give us the best judgment to ourselves to give advice to the clients on any particular matter. So that was the reason we have selected this topic, and hope you will find. As regards, as we all know, our ICAI head office has changed the process in which the virtual programs need to be conducted. I know it is little cumbersome for time now, but it's a very good move by digital engineering team, who have requested all the branches to launch the program on DLH platform, so that members across the country will know about this program and more gathering can happen, and we can have a more fruitful interactive for the sessions. So you may have certain issues in logging in or the link not opening. Maybe, sir, that could be the reason that attendance is a little low. By the time maybe another 5-10 minutes, the number of can go up as per my expectations. So request you to kindly bear with us and request you to be in touch with the managing committee or call on us if you have not got the link. The members write the email, will definitely share the link offline also. So thank you, Kamal sir. So I know it's a very big hectic schedule for all chartered accountants, and people like you, it is definitely a much needed help to all of us who has agreed us to address on such an important topic. I know you have a very hectic schedule. Thank you for accepting our invitation and agreeing to the Hyderabad branch members and also the members from other part of the city. So all the members say happy learning. Thank you for the secretary for the opportunity.
Thank you, Chairman sir, for your very valuable introduction and changeover to in the technology part. Now, I request. I will read out the brief profile of the speaker today, and then we'll move to the session. Kamal Garg sir is a fellow member of the Institute of Chartered Accountants of India, and is also an advocate from Delhi University. He is also qualified his post-qualification course in Diploma in Information Systems Audit, and he is an insolvency professional registered under IBBI. He is also qualified certificate course on BRSR conducted by ICAI. He was also the member of Board of Studies Study Material Research Group of NIRC of ICAI and a special invitee member of Accounting Standard Board. And also he is invitee of Financial Reporting Review Group of FRRB ICI and India's Implementation Committee of ICI. He was also nominated as a special invitee member to the Committee on Banking, Insurance and Pension of NIRC of ICI. He is also a resource person for Peer Review Board, Corporate Laws and Corporate Governance Committee, and Committee on Financial Market and Investors Protection of ICI. There is a lot of list of books written by him. For example, IFRS and India's Concepts and Applications, COVID-19 Guide to Financial Reporting Audit. There are so many books. Due to the time paucity, I am leaving them. He has to his credit the contribution of Gist of Accounting Standards and Auditing Assurance Standards for Volume 2, Company Law published by BLH, and various articles for NIRC and CIRC of ICI newsletter on FBT, MAT, US SOX, CARO, FEMA, etc. And a series of articles on Delhi value-added tax, taxation, accounting, auditing aspects for the General Tax and Corporate Referencer TCR, including various articles on external commercial borrowings, direct taxes and FDIs for TCR. He possesses a rich industry experience in the areas of corporate laws like Companies Act, FEMA, taxation, foreign collaborations, joint ventures, audits and management consultancy. Moreover, he is a regular resource person for our ICI, for which we are very thankful to you, sir. With this brief profile, I leave the session to you, sir.
Thank you, sir. Thank you very much. So good evening to each one. Yeah. Shall I start?
Chairman, sir, want to speak something?
Small announcement. Apologies for that. Members, it is humbly requested to please.
Voice.
Members, it is humbly requested to.
No.
Is it better now?
Yes. Okay. Little.
Jara sir, Jara, Nayara.
Members, it is a humbly requested.
No. Okay. Sorry for the technical glitches. Sir, speaker, sir, please continue.
Okay. I have a small query. Do I need to take up MCQs in the end?
Yes, sir.
Okay. So good evening to each one of you listening me, and I'm really thankful to Chairman Sir C.A. Deepak Ladda ji and a very good friend C.A. Ravi Shankar Reddy ji, whom I am seeing after a long gap. And I'm thankful to Hyderabad branch of SIRC of ICI for giving me this opportunity. So before I share my PPT, you must be wondering why this topic is useful for chartered accountants. This topic is useful for many good reasons and bad reasons also. Bad reason is nowadays the trend has been moving. If something happens bad, then chartered accountants are first of all called upon. So we must be aware about the legal provisions under Companies Act. The good reason is most of the chartered accountants are, having the DNA of taxation practice. So right from our articleship days and even today, most of the chartered accountants are having this taxation practice. I would suggest that litigation practice is also having a good scope. Now, in between litigation and compliance, there is a more area. And that area is known as corporate laws, advisory and strategy. Now, why this corporate law, advisory and strategy is important? The foundation for litigation, defense is the core. And you would be able to enter into that core only when you understand the provisions of the Companies Act, which I will be sharing and deliberating upon. I have a small question. How many of you are aware as to whether auditors are having any punishment involving imprisonment under Companies Act? Any idea? You can reply in the chat box whether auditors could be subjected to any imprisonment under the Companies Act. Is there any provision regarding the same? We'll discuss that thing also. For the time, you can take a note. Section number 147 of Companies Act 2013. Section number 147 of Companies Act 2013 entails provision regarding imprisonment of auditors. How we will see and delve upon. I'm sharing my PPT. Please confirm once my PPT is visible to you. Can somebody confirm whether my PPT is visible?
It's visible, sir.
Okay.
Sir.
Okay. So the topic given to me is arrest provisions under Companies Act 2013. I would request each one of you to please keep your notepad and pen ready, because I will be discussing some important elements which could be helpful to you in your day-to-day practice as well. Now, when we say Companies Act 2013, we need to understand what are the various punishments under Companies Act 2013. Each and every punishment is not entailing arrest. So if you see the broad structure of Companies Act and the punishments contained therein, the broad structure can be streamlined in this very chart. The punishments under Companies Act 2013 can comprise of penalty provisions, fine, imprisonment, both fine and imprisonment. So in Companies Act, we have several offenses. I repeat, in Companies Act, we have several offenses. These offenses may either be subjected to penalty or fine or imprisonment or both fine and imprisonment. Now, if we come to imprisonment, you will find many sections in Companies Act, even I will discuss some of the sections, which contain imprisonment, but in some sections, the imprisonment is provided by the section itself. I repeat, in certain sections, the imprisonment is provided by the section itself. But there are certain sections which state that the punishment shall be given in the manner as contained in section number 447. Section number 447 deals with punishment for fraud. Meaning thereby, when we come to arrest provisions, arrest means imprisonment. Now, when you come to arrest and imprisonment provisions, imprisonment can be discussed under two broad headings. One is the imprisonment which is provided by this section itself. And second, the imprisonment which is tied up with the punishment for fraud. Please take a note in your notepad that punishment for fraud is given by section 447 of the Companies Act 2013. Before I proceed further and show you the other screen, I have a small question for the audience. Please try to respond in the chat box. The question is there any difference between penalty and fine? Is there any difference between penalty and fine? And this question assumes special significance for a reason. The reason is, this is the area where chartered accountants can contribute a lot, and this is the area where chartered accountants can undertake practice as well. So what is the difference between penalty and fine? Any answer? Okay, I presume there is no answer, so let me proceed further. So I will discuss, first of all, adjudication of penalties. Now, just see the topic here, adjudication of penalties. The first bullet point to be discussed is difference between fine and penalty. Please take a note of the section number 454. Now, when I ask you the question, distinction between fine and penalty, please understand, see the first bullet point, punishment of fine and imprisonment, as the case may be, can be imposed only by the court. However, in certain cases, provision has been made for imposing penalty. So what you need to remember, fine and oblique or imprisonment, fine and oblique or imprisonment, as the case may be, can be imposed only by the court. But when it comes to penalty, penalty is imposed by the adjudicating officer. This adjudicating officer is nothing but registrar of companies. Section number 454, subsection 1. See the second bullet point. Such penalty can be adjudicated by a registrar of companies who is designated as one of the adjudicating officer. Section number 454, subsection number 1. Now, powers are given by section number 454. These powers can be exercised by the adjudication officer. Now, what are the powers? Under section number 454, subsection 3, the adjudicating officers have the following powers. So there are two powers. See first bullet point over here. I'm highlighting it. Just give me a moment. So adjudicating officer, adjudication officer under section number 454, subsection 3 are having two powers. Power number 1, impose the penalty. See the words, impose the penalty. The fine word is not used. So what you need to remember, fine will be imposed by the court, but penalty will be imposed by the adjudication officer. So first power is impose the penalty on the company, the officer who is in default, or any other person, This any other person could be even auditors. This any other person could be even auditors for any non-compliance or default under this act. The word is this means Companies Act. Meaning thereby, the adjudication officer by virtue of section number 454, has the powers to impose penalty. So question arises, can an adjudication officer file a case against you for the purpose of providing you punishment of imprisonment? Any answer? Can ROC file a case against you for the purpose of providing the punishment of imprisonment? Answer is yes. But how this yes will be intercalated, I will discuss separately. So what you need to remember, adjudication officer can levy penalty only under this act, and this penalty can be levied on three entities, or I should say three persons: company, the officer who is in default, and any other person. Please take a note, this any other person will include even the auditors. Now these auditors could be chartered accountants, company secretaries, cost accountants, etc., etc. Second power, the adjudication officer has the power to direct such company or officer who is in default or any other person, as a case may be, to rectify the default wherever he considers fit. So not only he can levy penalty, but he can also give directions to rectify the default. So these are the two powers. Now, section number 454, subsection 4 says, before he will levy penalty, opportunity of being heard shall be provided. Opportunity of being heard shall be provided. Now what he says, adjudication officer will say, I wish to levy penalty upon you for these offenses. Now for these offenses, he will issue you a show cause notice, SCN, that is show cause notice. This show cause notice shall provide you a time of minimum 15 days for up to 30 days to provide explanation as to why penalty shall not be imposed upon you. This 30-day period can further be extended to another 15 days. This 30 days period can further be extended to another 15 days. But this extension, if it's going to be given by the adjudication officer, can be given only for reasons to be recorded in writing. RIW means reasons to be recorded in writing. So meaning thereby, minimum 15 days need to be given. This 15 days time is given for the purpose of receiving the response from the person, from the offender, as to why penalty shall not be imposed upon him. The person so called upon to respond back may request the adjudication officer to give me some additional time to respond. The additional time can be given, and the time can be given for 30 days, that is 15 to 30 days, that is 15 days. So additional 15 days can be given. Now, it may happen that this whole 30-day period is not sufficient. Then the person so accused may still be given some additional time. But this additional time can be given for additional 15 days only. But this additional 15 days of time, that is beyond 30 days of period, this 15 days of additional time can be given only after recording reasons in writing. Only after recording reasons in writing. I have a small question for you. Please try to answer this question. The question is, Mr. X is the auditor of RST Private Limited. He resigned from auditorship, but failed to intimate the company, the registrar of companies. Can penalty be levied upon him under section 140 because he is neither the officer of the company and nor the KMP of the company? Yes, any answer? Any answer? So Mr. X is the auditor of RST Private Limited. He resigned. Now after his resignation, what happened? He failed. He failed to intimate the registrar of companies about the resignation. The question arises, because he failed to intimate ROC about the resignation, can the penalties be levied on such auditor? Because the auditor is saying, I am neither the officer of the company, I am nor the KMP of the company, then why the penalty shall be levied upon him? So whether any penalty can be levied upon him, any answer? Any answer? No answer? No answer? So first of all, okay, let me see the chat box. So Chairman sir says yes. So let us first understand what the law says. If you refer, for this purpose, we have section number 140. Section number 140. Section number 140, subsection 2 requires auditors to intimate ROC about their resignation. Section 143 contains penalty for contravention of section 140 subsection 2. And what is the penalty? The penalty is given by section number 140 subsection 3, and this penalty is leviable on the auditors. This penalty is rupees 50,000. This penalty is rupees 50,000 or his remuneration, whichever is less. Are you getting my point? Whichever is less. And if it is of continuing nature, and if this offense is of continuing nature, then further penalty is also leviable. Rupees 500 per day. Are you getting my point? So now, what is the contention here? The contention is the auditor was saying, I am neither the officer nor the KMP. Why the penalty shall be levied upon me? Penalty can be levied because the section itself says that penalty will be leviable. Now, in several sections of Companies Act, it is being provided that so and so penalty will be leviable. But question arises, who will levy this penalty? The question arises, who will levy this penalty? This penalty will be levied not by the court. This penalty will be levied not by the court, but by the adjudication officer. Now, who is the adjudication officer? The adjudicating officer is nothing but Registrar of Companies by virtue of section number 454. So if I go back, section number 454 will be invoked. Section number 454 will be invoked by Registrar of Companies. Then a show cause notice will be given to you for contravention of section number 140 subsection 2. And then penalty will be demanded from you under section number 140 subsection number 3. I believe this question is clear to each one of you. And by virtue of these words, any other person, the auditor is covered over here. I believe this question is clear to each one of you. So what you need to remember, simple thing is, whenever any section says so and so amount of penalty shall be leviable, in that very case, the question arises, who will levy this penalty? Who will impose this penalty? Always remember, such penalty shall be imposed only by the adjudicating officer. Now, who is the adjudicating officer? The adjudicating officer is Registrar of Companies under section number 454 of the Companies Act. And this penalty will be levied only after providing reasonable opportunity of being heard. This opportunity being heard will be provided by show cause notice. The period involved to respond back in such show cause notice is minimum 15 days and it can go maximum to 45 days. Now, when this 45-day period is given to you, in this very whole period, that is 15 plus 15 plus additional 15. In this whole span of time, you have to respond back. And then obviously, subject to your reply, the penalty may be levied, the penalty may not be levied. When I say penalty may not be levied, it means that the adjudicating officer may direct you to rectify the default. So there could be a possibility, that in my case study, that is this question, the adjudicating officer believes that your reply is having some substance. In such a case, he may not levy penalty. Rather, he may give you directions to rectify the default. Please understand, I'm not saying that he will do either of the two. That either he will levy penalty or he will direct rectification of default. He may do either of the two, or he may do both of the two. Are you getting my point? So both the things are there at his discretion. Whose discretion? Adjudicating officer. To make you people understand, let me give you illustrations of certain sections where penalty is leviable. Just to have a small background and brief background, I have compiled a list of certain sections which are quite prominent in day-to-day affairs. So point number 1, default in complying with provisions relating to intimation and display of registered office of the company and display the name of the company. Section number 12(8) is there. So section number 12, subsection number 8 says, if any default is made in complying with the provisions relating to intimation and display of the registered office of the company and display of the name of the company, in that very case, the company and every officer in default shall be liable to a penalty of rupees 1,000 for every day during which the default continues, but not exceeding rupees 1 lakh. The most common example which I am observing nowadays is that most of the companies are not writing SIN number on their letterhead. So we are not writing SIN number on your letterhead. If your website is not containing SIN number, it may lead to a penalty under section number 12. Number second example, default in sending copies of memorandum and articles to a member within 7 days of his request and on payment of the fees by such member. So member of the company paid you the fees and he requested you to furnish me the copy of memorandum and articles of association. 7 days expired, and within such 7 days, you never furnished the memorandum and articles to such member. In such a case, by virtue of section number 17, subsection number 2, the company and every officer in default shall be liable to a penalty of rupees 1,000 for each day during which such default continues, or rupees 1 lakh, whichever is less. Then, not refunding allotment money within 30 days if minimum subscription not received, and not filing return of allotment within 30 days. So this is one of the most common default. Failure to file return of allotment within 30 days. So if return of allotment is not filed within 30 days of the shares allotment, then by virtue of section number 39, subsection number 5, company and every officer in default shall be liable to a penalty for each default of rupees 1,000 for each day during which such default continues, or rupees 1 lakh, whichever is less. Then we have section number 42, subsection 10, dealing with private placement of securities. So if any default is made in private placement of securities, in that very sense, company, its promoters, now promoters are also covered, its promoters and directors shall be liable for a penalty which may extend to the amount raised through the private placement or rupees 2 crores, whichever is lower. Default in sending copies of audited financial statements to members and its inspection. So now you know very well that audited financial statements need to be sent to the members at least 21 days before the annual general meeting date. In such a case, if default is made, then by virtue of section number 136 of section 3, the company shall be liable to a penalty of rupees 20,000, and every officer of the company who is in default shall be liable to a penalty of rupees 5,000. Some more examples. You know very well that whenever board meetings are conducted, you need to send a 7 days notice for the board meeting. Now, what the section says, section number 173 subsection 4 says, if default is made in giving the required notice of board meeting, then a penalty of rupees 28,000 will be levied. If default is made in keeping the register of contracts or arrangements in which directors are interested and disclosure by directors of their interest. So if directors are interested in a contract and the register is not maintained about such interest, in that very case, by virtue of section number 189, subsection 6, a penalty of rupees 20,000 will be leviable. This is most common default. Default in keeping contract of service with the MD and whole-time director and allowing its inspection. Section number 190, subsection 3 says, company shall be liable to a penalty of rupees 28,000, and every officer of the company who is in default shall be liable to a penalty of rupees 5,000 for each default. I have a small case study out of my experience. Let me share one case study with you. Just give me a moment. I am sharing a case study with you. I should say I am asking a question to you. Question is, Mr. X was, or let me put this way, measures XYZ Private Limited is a family-owned company. Mr. X, Mr. Y, and Mr. Z are brothers, and directors in the company. The company appointed Mr. Y as its whole-time director by passing a board resolution. The letter of appointment was not issued, even was not prepared. In other words, the company is not having any document other than such board resolution for appointment as whole-time director. Whether any penalty is leviable under the Companies Act. Yes, any answer? The serious question very carefully. And this is a very common question. It is happening in most of the companies in India. The way regulators are active nowadays, it is the high time that we professionals must be vigilant about these kind of lapses, which at a macro level seems that are very small lapses, but the impact is quite cumbersome. So I read this question once again. Measures XYZ Private Limited is a family-owned company. Mr. X, Mr. Y, and Mr. Z are brothers and directors in the company. The company appointed Mr. Y as its whole-time director by passing a board resolution. The letter of appointment was not issued, even was not prepared. In other words, the company is not having any document other than such board resolution for appointment as whole-time director. Whether any penalty is leviable under Companies Act 2013. Any idea, any answer? Yes, any of the participant? So please understand, okay, let me put the question in a different way. Whether this board resolution is a kind of contract of the company with Mr. Y. Is it a contract with Mr. Y? Answer is no. Answer is no. So what they need to remember, such board resolution is not a contract. And hence, what will happen? Section number 190, subsection 3 will be attracted. Hence, there is a default in keeping contract of service with whole-time director. And accordingly, the company shall be liable to pay penalty as prescribed. This is nothing but section number 190, subsection number 2. I believe this point is clear to each one of you. Am I clear? Any doubt over here? So these are very, customary lapses, because, the people say chalta hai, it is going on because it is going on. But the way I said regulators are active, we must be vigilant as professionals to guide the companies properly so that they should not be into soup, they should not be in any kind of trouble. So up till now, what I touched upon is penalty. I believe each one of you is clear about the distinction between penalty and fine. I have discussed penalty, fine I'm yet to discuss. So what I'm trying to say, penalty is leviable, is imposable by adjudication officer. The powers to levy such penalty is given by section number 454. We discussed two instances which are quite prominent for the levy of penalty. One is resignation by the statutory auditor and not filing of the same with the registrar of companies. And second is the company is not keeping the contract of service with whole-time director. And this is the contravention of section number 190, and hence penalty is leviable under section number 190, subsection number 3. So question arises, who will levy this penalty? The penalty as above will be imposed by adjudication officer under section number 454. So I covered the first part regarding penalty. The penalty part is covered for a reason. Unless and until you will be able to understand the distinction between penalty and fine, the arrest provisions cannot be understood. So that's why I discussed penalty provisions first of all. So if you have any doubt about penalty provisions, you are most welcome to ask. There's no questions? Okay. Now, other issue is, I told you, if I go back, I told you that there are certain sections in which imprisonment is also mentioned, fine and imprisonment. So the question is, there are certain sections which provide punishment for offenses as follows: fine or imprisonment or both. Now, question arises when I say imprisonment. When I say imprisonment, it is quite obvious this can be given only by court. Now, the question arises, who will approach the court? Whether police office, whether ROC should approach police officer first and then such police officer should file charge sheet before the court. Yes, what is your take? Any answer about this question? So it is quite obvious that you must be aware, although I will be discussing separately, that there are many sections in Companies Act which says that the offenses shall be punishable with imprisonment. Now, if offenses are punishable with imprisonment, question arises, who will approach the court? Now, if I assume that ROC will approach the court, so question arises, can ROC directly approach the court, or whether ROC needs to file FIR first, and then such police officer will make investigations and then he will file charge sheet before the court? How the process will go on? Any idea? Okay, let us discuss this thing. So for this purpose, we have a very big section in Companies Act, section number 439. Now just see very carefully. Section number 439 says offenses under this act, this means Companies Act, offenses under this act to be non-cognizable. Offenses under this act to be non-cognizable. Now, question says, when can court take cognizance? When can court take cognizance? That means when the court will take into consideration the offense committed under the Companies Act for the purpose of imprisonment. So for this purpose, section 439 says, on complaint in writing from registrar of companies, shareholder of the company, member of the company, a person authorized by the central government, or a person authorized by SEBI only for the offenses relating to issue and transfer of securities and oblique or non-payment of dividends. So these are the 5 agreed parties. These are 5 agreed parties. Only on complaint by any of these 5 agreed parties, the court will take cognizance of the offenses committed under Companies Act. I repeat, only on written complaint of any of these 5 aggrieved parties, the court will take cognizance of the offenses committed under Companies Act. MCA notified on 5th June 2015 that in case of the government companies, the court shall take cognizance of any offense only on the complaint in writing of a person authorized by central government in that behalf. So if the case is of a non-government company, then central government need not be involved. But in the cases of a government company, then only the person authorized by central government in that behalf will be the person who will approach the court for the purpose of asking the court, requesting the court to take cognizance of the offenses made under the Companies Act. Now, it means that ROC need not approach police station for registration of FIR. ROC can directly approach to the court by taking the complaint in writing so that the court can take cognizance of the offense. And once the court will take cognizance of the offense, the provisions of CRPC, Criminal Procedure Code, will go parallelly with the Companies Act. I repeat, once the court will take cognizance of the offense committed under the Companies Act, thereafter, the provisions of Criminal Procedure Code, CRPC, will go parallelly along with the Companies Act 2013. I will discuss briefly that provision as well. So in my question, if I go back, who will approach the court? ROC will approach the court. I'm assuming ROC will approach the court because other 4 parties are still there. So I am assuming that in my question, ROC will approach the court. Now, when ROC will approach the court, he need not approach the police station for registration of FIR. He can directly approach the court with a request that offenses have been committed under Companies Act and the court shall take cognizance of the same. Once the court will take cognizance of the same, in that very sense, the provisions of CRPC will also follow. Having said that, question arises, what is the meaning of court? The expression court is defined in section number 2, clause 29 of the Companies Act. The expression court is defined in section 2, clause 29 of the Companies Act. As per section 2, clause 29 of the Companies Act, court means high court having jurisdiction, district court in cases where central government has by notification empowered any district court to exercise all or any of the jurisdiction, court of session having jurisdiction, special court established under section 435. This point number 4 is important because the central government has established special court exclusively for the purpose of Companies Act, and these courts have been established by notification under section number 435. We'll discuss separately. And number 5, court also means any metropolitan magistrate or a judicial magistrate of first class having jurisdiction. So I repeat once again, court means high court, district court, sessions court, special court, metropolitan magistrate or judicial magistrate of first class. Having said that, you know very well that if you wish to approach court, the very first thing which we need to check is whether the case is time barred or not, whether the case is time barred or not. So quite obviously, limitation provisions are also important. Quite obviously, limitation provisions are also important. Please remember, the limitation provisions regarding imprisonment, are contained in Criminal Procedure Code, CRPC. So for this purpose, we have section number 472, 468, and 469. Let us discuss 472 first of all. Section number 472 of CRPC deals with continuing offense. Section number 472 of CRPC says the offense continues till the provisions are complied with, and fresh period of limitation begins to run every moment of time during which offense continues. So fresh period of limitation begins to run every moment of time during which the offense continues. Hence, the question of limitation does not arise till offense continues. So question arises when the offense case will be time barred. So a case will be time barred depending upon the provisions given by section number 468. Section number 468 of CRPC says, what is the limitation? Limitation is 6 months if the offense is punishable only with a fine. Just be very careful. And this is the area where chartered accountants can strategize for their clients. So what is the limitation period? Limitation period is given by section 468 of CRPC, and section 468 CRPC says limitation is 6 months if the offense is punishable only with fine. Number 2, limitation is 1 year if offense is punishable with imprisonment not exceeding 1 year. And number 3, limitation is 3 years if the offense is punishable with imprisonment exceeding 1 year. So depending upon the limitation period, you have to decide whether a particular offense is a time barred case or not. I repeat, depending upon the limitation period given by section 468 of CRPC, one has to decide whether the offense is falling in a case which is time barred case or not. So let us have a recapitulation once again. As per section 468 of CRPC, limitation is 6 months if offense is punishable only with fine. limitation is 1 year. If offense is punishable with imprisonment not exceeding 1 year, limitation is 3 years. If offense is punishable with imprisonment exceeding 1 year. Having said that, we have section number 469. And section number 469 tells us when the period of limitation shall commence. When the period of limitation shall commence. So section number 469 says the period of limitation in relation to an offender shall commence on the date of offense or where the commission of offense was not known to the person aggrieved by the offense or to any police officer. See the word or. See the word or. This or word is very critical because this word or is dissecting two expressions. One expression is person aggrieved by the offense and second expression is police officer. I told you in my example, police officer was not involved. So question arises whether person aggrieved will include ROC. Registrar of Companies answer is yes. For this, we have a decided case law also. So always remember ROC will be deemed as aggrieved person for the purpose of offense made or committed under the Companies Act. So I will tell you the case in which it was decided that ROC is aggrieved person in few moments. Let us have a recapitulation once again. Section 469 says the period of limitation in relation to an offender shall commence on the date of offense itself or where the commission of offense was not known to the person aggrieved by the offense or to any police officer as the case may be, the first day on which such offense comes to the knowledge of such person or to any police officer, whichever is earlier, or where it is not known by whom the offense is committed, where it is not known by whom the offense was committed, the first day on which the identity of the offender is known to the person aggrieved by the offense or to the police officer making investigation into the offense, whichever is earlier. So ultimately, if I say as a layman, the period of limitation will commence either on the date of offense itself or number second, if the offense commission came to your knowledge at a later stage, then the period of limitation shall commence from the date on which such offense commission came to your knowledge. I told you that this word or is very critical word. Why? Because this word or is dissecting two expressions. One is person aggrieved and second is police officer. Police officer is of no use at present in my discussion. Question arises, what is the meaning of person aggrieved? So if Companies Act provisions are contravened, who will be aggrieved party? Shareholder could be aggrieved, member of the company could be aggrieved, but question arises, can ROC be aggrieved party? Answer is yes, ROC can also be aggrieved party. And for this purpose, we have a decided case law. Supreme Court in Rajeshri Sugar case held that ROC is a person aggrieved within the meaning of section 469 of CRPC, and hence he can file a case within the time limit specified under section 468 of CRPC after offense came to his knowledge. So section 468 was telling you period of limitation. Section 469 is telling you when the limitation period will commence. So what you need to remember, if I go back to my preceding clip, this ROC, this shareholder, this member, this person authorized by central government, this person authorized by SEBI, all these can be agreed persons. All these can be agreed persons. And that is the reason the section says on complaint in writing from these persons. So all these 5 persons can be agreed persons for the purpose of section number 469 of CRPC, for the purpose of approaching court so that the court can take cognizance of the offense. Some people were having the contention that ROC cannot be agreed because no loss has been caused to ROC. So if company does some offense, shareholder may be agreed because loss was committed against the shareholder. Member was agreed because loss was committed against the member. The question arises, ROC nowhere is at loss. Because ROC is nowhere at loss, then how come ROC can be taken as agreed party? For this purpose, the contentions were put to rest by the Supreme Court in Rajeshri Sugar case, and Supreme Court stated ROC is also an agreed person. Now, what Supreme Court decided in detail, you can refer by visiting Google and searching this case law. I have given the citation also. So what you need to remember, for imprisonment scenarios, ROC can also approach the court so that the court can take cognizance of the offense, and then obviously trial will begin, and after trial, whatever conclusion will be there, depending upon that conclusion, the imprisonment will be sanctioned. Having said that, let us have a case study, a very simple case study. to make people understand the gravity of these sections. Now, what happened in Ramesh Chandra Sharma case, Delhi High Court decided and held that court must see whether a complaint presented was within limitation or not while taking cognizance of offense. So Delhi High Court also stated and held court must see whether a complaint presented was within limitation or not while taking cognizance of offense. So this case is having certain ratios and facts. Let us undergo those ratios and facts. So what happened in this case, Registrar of Companies issued a show cause notice for prosecution to petitioner on the ground that balance sheet, profit and loss account for financial years 13-14 had shown income from operations without proper disclosures having been made, and thus petitioner violated provisions of section number 129. So what happened, if I say the summary, in this case law, what happened, the company prepared the financial statements, but notes to accounts were not properly prepared. So there were inadequate, improper disclosures in notes to accounts regarding income from operations. So just see once again, ROC issued show cause notice for prosecution to the petitioner on the ground that balance sheet, profit and loss account for the financial years 2013 and 2014 had shown income from operations, but without proper disclosures having been made, and thus petitioner violated the provisions of section number 129. To recapitulate, section 129 deals with preparation and presentation of financial statements in accordance with Schedule 3 and applicable accounting standards. Since response of petitioner was not satisfactory, complaint was filed by ROC under section number 129 read with section 439. So I believe this sentence is clear to each one of you. Offense was committed under section number 129. So ROC will approach court to take cognizance of this offense. How he will approach court? He will approach court by complaint in writing. And this provision is contained in section number 439. The complaint was accompanied by the application for condonation of delay. The court took cognizance of the offense to summon petitioner to face trial in complaint cases. So court issued summon to the petitioner that trial will be commencing against you. Now, what is the peculiar thing here? The complaint which was filed by ROC, was also accompanied by application for condonation of delay. What is the condonation of delay? Condonation of delay means, I presume, that the ROC approached the court, but ROC approached the court after expiry of this limitation period. So what happened? The court held, that is Delhi High Court held, that while taking cognizance, the court has to apply its mind as to whether complaint presented was within period of limitation or not. Further, the court must also consider whether there were sufficient grounds to condone delay that would have occurred in presentation of complaint. Since in the instant case, the court overlooked filing of application for condonation of delay. So what happened in this case? This application was filed for condonation of delay, but the district court ignored this application. And thus, Delhi High Court stated, thus, mind had not been applied by the court to the question of condonation of delay. Thus, impugned order passed by the court was to be set aside and matter was to be remanded back to the trial court, to consider application for condonation of delay. So what is our scenario over here? Because the trial court ignored the condonation application. This ignorance by the trial court became a big defense for the petitioner, and High Court of Delhi gave a relief to the petitioner by remanding this case back to the court. That is the trial court. There's a question in the chat box I can see in the Q&A session, in the Q&A chat box. Can a resolution professional invoke section 129 read with section 439 either directly or through the ROC? Sir, as far as resolution professional is concerned, resolution professional can invoke section 129 read with section 439 by applying section number 19 and 20 of IBC. So resolution professional can approach, as he is also one of the agreed party. But in that very case, he need to invoke section number 19 and 20 of IBC, Insolvency and Bankruptcy Code. I believe this point is clear. Vijay Kumar ji, this point is clear. Any other question? So there is no other question I can see in the chat box. Okay. Now I have prepared a list of some of the significant sections in which the offenses are punishable with imprisonment. So just have a look one by one. Guilty of tampering with the minutes of the meeting, section number 118, subsection 12. It gives you imprisonment and it can extend up to 2 years. Restrictions on purchase by company or giving of loans by it for purchase of shares. So no company can give you loan to buy its own shares. There are certain exceptions, but I'm simply giving a macro view. So under section number 67, subsection 5, if company give loan for the purpose of purchasing its own shares, then there could be imprisonment that can extend up to 3 years. Financial statement shall give a true and fair view of the state of affairs of the company and comply with the accounting standards. If this is not complied with, then section 129 is contravened and imprisonment can extend up to 1 year. Auditor has contravened section 139. Section 139 deals with appointment of auditor. Section 144 deals with other services to be provided by the auditors. Section 145 deals with signing of audit report by the auditors. So if the auditors have contravened section number 139, section number 144, or section number 145 knowingly or willfully with the intention to deceive the company or its shareholders or creditors or tax authorities, then in such case, auditors can be subjected to imprisonment for up to 1 year. Loans and investments are made by the company in contravention of section 186. Imprisonment can be there that can extend up to 2 years. Deposits are accepted in contravention of section 73 or 76. Imprisonment can be there for up to 7 years. Loan in advance. Loan is advanced or guarantee or security is given or provided or utilized in contravention of section 185. I must tell you, section 185 deals with prohibition for providing loan or guarantee or security to directors of the company. So if directors are given loan, guarantee or security in contravention of section 185, then imprisonment can be there that can extend to 6 months. Then is personation of shareholders. So if any person is impersonating as a shareholder of the company, despite the fact that he's not a shareholder of the company, in that very case, such person can be subjected to imprisonment up to 3 years. Then is contravention of order of the tribunal with respect to refusal to register the transfer of any securities or interest of a member in the company. So tribunal gave the order, that is NCLT gave the order for registration of transfer of shares, but the company refused to comply with that order. In that very case, the directors and the officers in default can be subjected to imprisonment that can extend up to 3 years. So if you see, the imprisonment period is given. Extend to 2 years, extend to 3 years, extend to 1 year, extend to 1 year, extend to 2 years, 7 years, 6 months, 3 years, 3 years. Now, I'm going back to the preceding clip. See this limitation period. Now, limitation is 6 months if the offense is punishable with fine, only with fine. Limitation is 1 year if offense is punishable with imprisonment not exceeding 1 year. Limitation is 3 years if the offense is punishable with imprisonment exceeding 1 year. So please tell me, out of these 9 offenses listed before you, what is that offense? What is that offense in which the limitation period is only 1 year? In which limitation period is only 1 year? So please tell me by looking on these 9 listed offenses. Out of these 9 listed offenses, please tell me which one of the offense is having the time bar period that is 1 year limitation. So just see this number 7. The imprisonment can extend up to 6 months. So here it will be nothing but 1 year limitation period. Why? Limitation is 1 year if offense is punishable with imprisonment not exceeding 1 year. So it is up to 1 year period. In case the imprisonment is not exceeding 1 year. In my example here, the imprisonment can extend up to 6 months. So limitation period here is only 1 year. In all the other cases, same way we have to analyze. Like 2 years, 3 years. In 2 years, 3 years, what will happen? Limitation period will become 3 years. Extend to 1 year, it will nothing but limitation period is 1 year, and so on. Now, I told you in the very beginning that there are certain offenses which are tied up with the offenses of fraud. Let us discuss those things also. But prior to discussing those things, let us understand what is the punishment for fraud under section number 447. Section 447 says, without prejudice to any liability, including repayment of any debt under this act or any other law for the timing in force. So what you need to remember, section 447 has made it amply clear that whatever repercussions can arise under any other law for the timing in force regarding fraud, they will survive. And whatever punishment section 447 is providing, that is in addition to whatever liabilities are provided by any other law for the timing in force. Just have a look out once again. Section 447 says, without prejudice to any liability, including repayment of any debt under this act or any other law for the timing in force, any person who is found to be guilty of fraud involving an amount of at least rupees 10 lakhs or 1% of turnover of the company, whichever is lower, or 1% of turnover of the company, whichever is lower, he shall be punishable with imprisonment of at least 6 months, but which may extend up to 10 years, and fine of at least the amount involved in the fraud, but which may extend up to 3 times the amount involved in the fraud. On the other hand, if the fraud in the question involves public interest, then this imprisonment of minimum 6 months shall be minimum 3 years. So whenever public interest is involved, minimum imprisonment for fraud is 3 years. Section 447 further states that where the fraud involves an amount less than rupees 10 lakhs or 1% of turnover of the company, whichever is lower, that means less than this amount, and does not involve public interest, any person guilty of such fraud shall be punishable with imprisonment for a term which may extend to 5 years, or with fine which may extend to rupees 50 lakhs, or with both. The motive is not here to teach you what section 447 states. The motive is to teach you that section 447 also involves imprisonment and fine. So who will levy this fine? Who will give this imprisonment? Court, not the ROC. So how this fine and imprisonment will be granted by the court, will be levied by the court? Only on complaint in writing by virtue of section number 439. So ROC or shareholder or member or person authorized by central government or person authorized by SEBI, these people will approach the court by complaint in writing for the purpose of inflicting the punishment given by section number 447. So complaint will be drafted for section 447 and you will approach the court by virtue of section 429. Then the court will take cognizance of the offense and the trial will begin. Now question arises, what is fraud? The expression fraud is also defined by explanation below section 447. Expression fraud being defined in this manner: fraud in relation to affairs of the company or any body corporate includes any act, omission, concealment of any fact, or abuse of position committed by any person or any other person with the connivance in any manner, with the intent to deceive, to gain undue advantage from, or to injure the interest of the company or its shareholders or its creditors or any other person, whether or not there is any wrongful gain or wrongful loss. Wrongful gain is also defined to mean the gain by unlawful means of the property to which the person gaining is not legally entitled. As a corollary, wrongful loss is also defined to mean the loss by unlawful means of the property to which the person losing is legally entitled. If you see this definition at a macro level, you will say this definition is extremely simple. I must ask you one question at this point of time. The question is, say the company is RST Private Limited and it is in the business of manufacturing and selling beauty products. This company engaged, say, Madhuri Dixit for promotion of such beauty products as brand ambassador. The customers bought the product and developed skin disease after usage thereof. Question: can Madhuri Dixit be held guilty of fraud under Section 447 of the Companies Act? Yes. Any answer? Any answer? So you must be having clients who are engaging brand ambassadors. So in that very case, this question assumes special significance. What is your view? Can Madhuri Dixit be held guilty of fraud under Section 447 of the Companies Act? Just see the definition of fraud and please try to respond back. See this definition of fraud and I will give you 30 seconds to check and reply back. Yes, any answer? No answer? Deepak Ladda ji, any answer from your side? Ravi sir says yes, I think. So just have a look over here and let me emphasize something. Fraud includes any act, omission, concealment of any fact, abuse of position. Abuse of position. Position means the influential position. Madhuri Dixit is having influential position. Abuse of position committed by any person. Any person here means Madhuri Dixit. With the connivance in any manner. Connivance means with the directors. Because directors must have approached the actor, na, that you should come and become our brand ambassador. With the intent to deceive, to gain undue advantage from, or to injure the interest of the company or its shareholders or its creditors or any other person, whether or not there is any wrongful gain or loss. Forget about this word intent. I will come to this word intention later on. Come here, to injure the interest of the company or its shareholders or its creditors. Now the customers are neither the company, nor the shareholders, nor the creditors, but they will fall in other persons. So customers are falling within any other person. So Madhuri Dixit will be implicated in fraud only when it is also established that she was having intention to deceive or to gain undue advantage from. Unless and until this intention is established, she will not be implicated in this definition of fraud. So ultimate is who will establish the intention? The intention will be established only through trial court. I repeat, the intention shall be established only through trial court. Are you getting my point? Meaning thereby, there are two different things. One is filing of complaint and second is beginning of trial. Are you getting my point? One is filing of complaint and second is beginning of trial. In my question, what will happen? The answer is, it will lead to two-way step. ROC may file complaint under Section 439 for cognizance of offense of fraud. Then afterwards, trial will begin and the court will decide whether Madhuri Dixit is guilty of fraud or not. So what is the tip? The tip is, if you are consulted on Madhuri Dixit, apply for anticipatory bail under Section 438 and 439 of the CRPC.
Sir, Kamal sir, can I interrupt?
Yes, sir, please, sir.
I think even in the recent Consumer Protection Bill Act also it is.
Yes, sir, you are right. You are right. So what will happen, no, sir? That Consumer Protection Bill will be a double-edged sword. One is the case under Consumer Forum, Second is the case, because in consumer forum, what will happen? It will be a case for recovery of damages. But in company law, that person so authorized may also approach under section 439, because the words use a person authorized by central government.
Yes.
So double-edged sword, it will be having the interplay.
Yes. Thank you, sir.
So I believe this question is clear. This case study is clear. So what my suggestion is, if you are the consultant of Madhuri Dixit, and Madhuri Dixit approaches you that I'm going to become a brand ambassador of RST Private Limited, in that very case, always draft the agreement or the contract in such a fashion that the intention is made clear. The intention must be only confined to promotion of the product without any other if and buts. So this way, the chartered accountants can help the people in general public for their commercial arrangements and commercial contracts. Now, it is the right time to understand, I told in the beginning that there are certain areas of imprisonment which are tied up with the punishment of fraud, meaning thereby the company law at several places has stated that if this is contravened, then same punishment will be there as is mentioned in section number 447. So let us have a look out on those very sections. So these are 9 points again. So there are many other sections, but I have compiled a list of some important sections only. So first one is furnishing any false or incorrect particulars of any information or suppressing any material information with respect to registration of the company. So you incorporated a company, but you furnished false information or you suppress some material information. In that very case, section number 7, subsection 5 and section number 7, subsection 6 says that the offender will be punished with the same quantum of punishment which is mentioned in section number 447. So all these 9 points are punishable for same quantum of punishment which is mentioned in section number 447. Similarly, section 34 says criminal liability will be there for misstatements in prospectus. Section 36 says if you are inducing persons on fraudulent basis to invest money in the company, then they will be subjected to the penalty. I should not say penalty. They will be subjected to the punishment in the same way as is mentioned in section number 447. Then section number 38 says if you are impersonating for the purpose of acquisition of securities in the company, then 447 quantum will be levied upon you as a punishment. Section 76A is there, which says if deposits are accepted in contravention of section 73 or 76 knowingly or willfully with the intention to deceive the company or the shareholders or depositors or creditors or the trust authorities, then what will happen? In that very case, the same quantum of punishment will be levied as is given in section number 447. If duplicate certificate of shares have been issued, but the intention is to defraud, then 447 quantum will be levied by virtue of section 46(5). If the depository or depository participant with the intention to defraud a person has transferred the shares, then even depository or depository participant, they will be inflicted with the same punishment as is mentioned under section number 447. Where this is written? This is written in section number 56, subsection number 7. Then registration of charges. Now, registration of charges is your almost daily affair. So section number 86 says, if while registration of charges, you have furnished any false or incorrect information, or you are knowingly suppressing any material information, then the same punishment will be levied as is mentioned in section number 447. Similarly, the company went for reduction of capital, but capital reduction was requested from NCLT by concealing and misrepresenting some information. Then what will happen? The same punishment will be levied as is mentioned in section number 447. So this is a small list as a matter of indication only. The main point of understanding is imprisonment can take place in 2 ways. One, the section itself says imprisonment. And second, the section says the quantum of punishment will be same as is given by section 447. Now, why I am saying section 447? Because certain punishments are tied up with the section 447 punishment of fraud, and in punishment of fraud, imprisonment is also given. Now, I will touch upon SFIO now, but before I proceed further, if you have any question, please, you are most welcome to ask. Up till now, whatever I discussed is purely administrative in nature. So whatever happens is happening indoors the company. ROC came to know that something bad happened indoors, and then either he will levy the penalty or he will go for imprisonment episode with the help of section number 439. Now, besides indoor happenings, some outdoor happenings can also take place. When I say outdoor happening, this outdoor happening is nothing but investigation by Serious Fraud Investigation Office, SFIO. Even SFIO proceedings are tied up with section number 447. For SFIO proceedings, that is SFIO investigation, we have section number 211 and section number 212. Just see very carefully. Section 211 and section 212 read together, but says SFIO, that is Serious Fraud Investigation Office, shall have head director an optimum combination of experts who shall be appointed by central government. So this is nothing but the constitution of SFIO. Now the law says the substantive provisions are central government may assign investigation into affairs of the company to SFIO. So central government is empowered to assign investigation into the affairs of the company to the Serious Fraud Investigation Office. But when the central government may assign investigation into affairs of the company to SFIO on the inspection report of ROC, so ROC can inspect, and on his inspection report, central government may assign investigation to SFIO, or the members of the company have passed a special resolution and have approached central government that please let SFIO to investigate affairs of the company. So CG means central government, may assign investigation into affairs of the company to SFIO on even the request of the members of company accompanied by their special resolution. Then is number third, public interest basis. So if central government is of the opinion that public interest is involved and the company affairs are prejudicial to the public interest and the company's affair needs to be investigated, in that very case, even central government may assign investigation to SFIO. And number four, the request is received by central government from any department of central government or state government. For example, the income tax department approached MCA, central government here means MCA, that please this company be investigated by SFIO. Then on such request, the Ministry of Corporate Affairs may assign the investigation case to SFIO, Serious Fraud Investigation Office. Now, what is the main point? When SFIO investigation is going on, until SFIO investigations are completed, what is the scenario? Other investigations under this act shall not commence or continue during SFIO proceedings. So please remember this word, this. So when SFIO investigations are going on, other investigations under the Companies Act will be halted. Please understand, only other investigations under the Companies Act will be halted. There will be no halt on the investigations being carried out under any other law for the time being in force. For example, the SFIO investigation is going on against RST Private Limited. The RST Private Limited is also being investigated by Enforcement Directorate under PMLA, Prevention of Money Laundering Act. Question arises whether PMLA investigation will stop if SFIO steps in. Answer is no, because only investigation under companies that will stop. So let me ask you a question a different way. Please try to respond back. If NAFRA investigation is going on, and meanwhile SFIO investigation also commences, so question arises whether NAFRA investigation will stop or it will still go on. You can respond your answer in Q&A chat box. Whether NAFRA investigation will stop or it will still go on. Answer is it will stop, because NAFRA investigation is under this act, under Companies Act. So it meaning thereby, if SFIO proceeding starts, then whatever NAFRA proceedings are going on, it will stop there and then until SFIO proceedings are concluded. The law further says, offense under section 447 of this act. Offense under section 447. 447 means punishment of fraud. Offense under section 447 of this act to be cognizable, an accused person cannot be generally released on bail or bond. Can you please tell me what is the meaning of this sentence? Very dangerous sentence. Offense under this act by virtue of section 447 shall be cognizable. An accused person cannot be generally released on bail or bond. Meaning thereby, if the person is found guilty of Section 447 by SFIO, then SFIO need not approach trial court for the purpose of cognizance of offense and arrest of that person. The SFIO people can arrest for those offenses which are under Section 447. So meaning thereby SFIO need not approach the court for the purpose of cognizance of offense, because SFIO itself has the powers to take cognizance of those offenses which are falling in the purview of section number 447. And once such person is arrested by SFIO after taking cognizance of such offense, such accused person cannot generally be released on bail or bond. The word is used generally. That means there could be certain exceptions. That means what are the exceptions? When such person who is accused under section 447 can be released on bail or bond. I will discuss that exception separately. Now the law further says central government may direct SFIO to prosecute against company and its officers or employees or any other person on the basis of investigation report. Meaning thereby central government has the powers to direct SFIO to prosecute against the company even and its officers or employees or any other person on the basis of investigation report. SFIO shall share the information, explanation to other authorities as well. So whatever findings are made by SFIO is duty bound, shall word is used, to share that information or explanation as the case may be to other authorities. Now who can be other authorities? It could be Department of Income Tax, police officers, Enforcement Directorate, etc. if it's for use of these other authorities. SFIO shall submit its report on investigation into affairs of the company to central government. Quite obviously, because central government is appointed SFIO to carry out investigation, the report shall also be submitted to central government only. Now we have section number 212 subsection 8. Section number 212 subsection 8 says, if any officer not below the rank of assistant director of SFIO. So you need to remember the rank. If any officer not below the rank of assistant director of SFIO authorized in this behalf by the central government by general or special order has on the basis of material in his possession to believe, the reason for such belief to be recorded in writing, that any person has been guilty of any offense punishable under section 447, he may arrest such person and shall, as soon as may be, inform him grounds of such arrest. Very dangerous power. Please understand, SFIO can arrest you only on the belief that you are guilty of offense of fraud. I repeat, SFIO can arrest you only on the belief that you are guilty of offense under section 447. Whether de facto you are guilty of fraud or not will be decided by the court at a later stage after arrest, when the trial will begin. So trial will determine whether you are guilty of fraud or not. But SFIO will arrest merely on the belief that you may probably be guilty of offense punishable for fraud. But there is a control mechanism. The control mechanism is the reasons for such belief. The reasons for such belief made by SFIO shall be recorded in writing. So whatever reasons SFIO is having for your arrest, these reasons shall be recorded in writing. Such officer who is making this belief and then he is arresting you, such officer shall immediately after arrest of such person forward a copy of the order along with the material in his possession, referred to in subsection number 8, to the SFIO in sealed envelope. So sealed envelope will be given to SFIO. But you need to remember, there are two different things. One is arrest and second is determination, whether you are guilty of fraud or not. Determination of guilt will take place in trial court, but arrest will take prior to that. Who will arrest you? A person being an officer of SFIO not below the rank of assistant director of SFIO. He will arrest you only on reasons to believe that you are guilty of an offense of fraud. But these reasons must be recorded in writing by him. So there are certain arrest rules which were notified, and these rules are known as companies arrests in connection with investigation by SFIO rules. So what are the arrest rules? Who can arrest you? So there are two cases. Other than for an investigation of government or foreign company, investigation of government company or foreign company. So if it's a case of other than government company or foreign company, the law says who can arrest? Director of SFIU can arrest. Additional director of SFIU can arrest. Assistant director of SFIU can arrest. So director, additional director, assistant director of SFIU has, on basis of material in his possession, reasons to believe, the reasons for such belief to be recorded in writing, that any person has been guilty of any offense punishable under section 212, of that he may arrest such person. This offense punishable under 212 means fraud offense. In case of an arrest being made by additional director or assistant director, then prior written approval of director SFIU shall be obtained. Meaning thereby, if this person, I am pointing to the laser pointer, if this person or this person, if any of these persons are making an arrest, then these two persons, as the case may be, need prior written approval of director SFIU. Whereas if the case is of a government company or foreign company, if the case is of a government company or foreign company, then arrest can be made only after obtaining prior written approval of central government. So central government needs to give you permission first of all. Who is the central government here? MCA, Ministry of Corporate Affairs. Intimation of such arrest shall also be given to managing director or person in charge of the affairs of the government company. But the person arrested is the managing director or person in charge of government company. Intimation to secretary of administrative ministry concerned shall also be given by the arresting officer. So for example, if any person, say, if any person is arrested, say from Coal India Limited, in that very case, the officer of SFIO shall also intimate Ministry of Coal that I have arrested a particular person being MD or person in charge of Coal India Limited. This is only for the academic sake. I am giving an example. Real world, it has not happened. So what you need to remember, in case of government company, prior approval of central government is also required. And if MD is arrested, and I mean the MD of government company is arrested, then the secretary of the concerned administrative ministry shall also be informed about the same arrest. Rule number 4 of arrest rule says, the director, additional director or assistant director shall sign the arrest order together with personal search memo in the form appended to these rules and shall serve it on the arrestee and obtain written acknowledgement of the service. Rule 5 says, the director, additional director or assistant director shall forward a copy of arrest order along with the material in his possession and all the other documents including personal search memo to the office of director SFIO in the sealed envelope with a forwarding letter after signing each page of these documents so as to reach the office of director SFIO within 24 hours through the quickest possible means. Rule 6 says, the director or any officer nominated by the director shall ensure that entries with regard to the particulars of the arrestee, date and time of the arrest, and other relevant information pertaining to arrest are made in arrest register in respect of all the arrests made by the arresting officers. The rule further says, rule number 7 says, the entry regarding arrest of the person and information given to such person shall be made in the arrest register immediately on receipt of the documents as specified in the rule 5 in the arrest register maintained by SFIO office. So what was rule 5? Just see once again. Rule 5 is you have to provide information to SFIO within 24 hours. So within 24 hours, you will receive the information and immediately on such receipt, you will make the entry into the register. Now this word immediately is a loophole. So some, this word immediately can be misused also. Rule number 8 says, the office of director SFIO shall preserve the copy of arrest order together with supporting materials for a period of 5 years from the date of judgment or final order of the trial court in cases where the said judgment has not been impugned by the accused in the appellate court, or from the date of disposal of the matter before the first appellate court in cases where the said judgment or final order has been impugned, whichever is later. So 5 years period preservation is required after the order of the appellate court or the trial court, as the case may be. This is very important. Rule number 9. The provisions of CRPC shall also apply mutatis mutandis for every arrest being made under the Companies Act. I touched upon CRPC a bit in the middle of my session. So you need to remember, criminal procedure code provisions are also important. Like for example, I discussed with you time barred cases scenario. So 468, 469 section of CRPC was discussed with you. So what you need to remember, CRPC provisions go hand in hand with the arrest provisions under Companies Act. I asked you one question that time and then I deferred. Generally, people are not released on bail or bond. So there must be some exceptions. So when the accused can be released by SFIO on bail or bond, for this we have the exceptions. Section 212 subsection 6 says, no person accused of an offense, that is offense punishable with fraud, shall be released on bail or bond unless, these two are the exceptions, unless the public prosecutor has been given an opportunity to oppose the application for such release. Who is public prosecutor? Public prosecutor is appointed by central government under section number 443 to represent the state and ROC. So when a person will be released on bail or bond, exception is the public prosecutor has been given an opportunity to oppose the application for such release, and where public prosecutor opposes the application, the court is satisfied that there are reasonable grounds for believing that he is not guilty of such offense and he is not likely to commit any offense while on bail. Further, second exception is a person who is under age of 16 years or is a woman or is sick or infirm person, then he or she may be released on bail if special court so directs. So ultimately, court is getting involved for the purpose of bail. SFIO directly don't have any powers. So bail will be given subject to the involvement of public prosecutor, trial court, and the special court as the case may be. This is a very good case law which will be helpful for advising the clients. In SFIO versus Rahul Modi, Supreme Court held that the accused in fraud case under section 447 has no right to statutory bail, Sometimes it is also called as default bail. The accused in fraud case under section 447 has no right to statutory bail as a matter of right if charge sheet has been filed within statutory period of 60 days under section 167 subsection 2 of CRPC, even though cognizance of offense has not been taken before expiry of statutory period. Now, what does this section 167.2 says for this 60-day period? So proviso A second of section 167.2 section CRPC is relevant over here. It says that when investigation cannot be completed in 24 hours of the arrest. So when investigation cannot be completed in 24 hours of the arrest, then no magistrate shall authorize the detention of the accused person in custody for a total period exceeding 60 days. And the accused person shall be released on bail if he is prepared to and does furnish bail. So this 60 days period is known as default bail period. So Supreme Court stated, if SFIO filed charge sheet prior to expiry of this 60-day period, then default bail right is not available, even if the court has not taken cognizance of the offense. So it may happen that the court might not have started trial. The offense has not been taken cognizance of, but charge sheet has been filed within 60 days of the arrest. In that very case, the accused cannot claim default bail as a matter of his right. That is what Supreme Court decided in SFIO versus Rahul Modi case. I believe this point is clear to each one of you. Now, section 227 is also relevant over here. Section 227 says that legal advisors shall not be bound to disclose any privileged communication made to them except the name and address of their clients. So investigation was going on by SFIO. SFIO was investigating. So section 227 says, during the course of investigation, legal advisors and bankers are not duty bound to disclose certain information. So number one is, during the course of investigation, legal advisors shall not be bound to disclose any privileged communication made to them except the name and address of their client. Section 227 further says, during the course of investigation, bankers shall not be bound to furnish information about the state of affairs of any of their customers other than such body, corporate, company, or person. So bankers are also provided immunity. Legal advisors are also provided immunity from disclosing information to SFIO during the course of investigation. But what they have to disclose? They have to disclose the name of the client and address of the client. So meaning thereby, the name RST Private Limited shall be disclosed. The address of RST Private Limited shall also be disclosed. But other than these two information, no piece of information is required to be disclosed to SFIO. By whom? By legal advisors and the bankers of RST Private Limited during the course of investigation. Now I have a small question. The words used are legal advisors. Whether auditors are having immunity. So if you are the auditor of RST Private Limited, are you having the immunity? Answer is no. Answer is no. Please take a note. Auditors are having no immunity. Only legal advisors are having the immunity. Who are the legal advisors? Advocates. So advocates have the immunity, but auditors have no immunity. Neither statutory auditors, nor cost auditors, nor secretarial auditors, nor internal audit. No auditor has any immunity under section number 227. So if SFIO calls upon the statutory auditor to disclose certain information about RST Private Limited, then such auditor cannot say that I am having the privilege under section 227, because that right of privilege is only to legal advisors and bankers and not to the auditors. Now, section 452, penalty for wrongful withholding of company's property. So let us take a situation. Companies RST Private Limited, and RST Private Limited has given a flat to be occupied by the director. After a few years, the director was terminated from his job, but despite termination, the director is not vacating the apartment given by the company for his accommodation. Question arises, what will be the repercussion on the director vis-a-vis the company's apartment as property? With this background, section 450 needs to be studied. Now, section 452 says that who can be complainant? Company, member of the company, creditor of the company, and contributory of the company can be complainant. What can be the nature of complaint? Under section 452, it is stated that where an officer or employee of the company, has wrongfully obtained possession of the company's property, including cash of the company, or he is being already in the possession of any company's property, including cash of the company, but wrongfully withholds it or knowingly applies it for unauthorized purposes, then these complainants can file a complaint to the court. In Kanakati Gopal Krishna Nair case, it was held that company's property may come in company's possession either by rent, lease, or other legal mode. So the company took apartment on lease and gave this apartment for residential accommodation of the director. Director was terminated from his services, but the director still is not vacating the property. In that very case, he will fall in case number 2. He is already in possession of company's apartment, but is wrongfully withholding it because after termination of the job, he cannot hold this property. Then what will happen? In such a case, either of these 4 can be complainant and can approach the court with the complaint in writing. Now, what will happen? The court will take cognizance of this complaint, and then court may order punishment. Now, what court can order punishment? Number 1, fine of at least rupees 1 lakh, which can extend up to rupees 5 lakhs. I told you penalty can be levied by adjudication officer and fine can be levied by the court only. Court may also order for delivery or refund of the company's property within specified time. So it may happen that such a director against whom the court has given the order is not complying with the court order. Then what will happen? Non-compliance with the court orders may result in up to 2 years of imprisonment. The word used was officer or employee. So for the purpose of section 452, both existing as well as past officers or employees are covered. In Baldev Krishna Sahi case, it was held that property obtained during employment but wrongfully withheld even after the cessation of employment, complaint under section 452 can be filed. Again, in Srimati Abhilash Vinod Kumar Jain versus Cox and Kings India Limited case, it was held that term officer or employee of a company would by a deeming fiction include legal hires and representatives of the employee or officer concerned continuing in occupation of the property of the company after the death of the employee or the officer. So in my example, let us assume the director was terminated from the service. He was still occupying the company's flat or apartment wrongfully, and meanwhile he passed away. Question arises, can the proceedings be continued against his legal hires? Answer is yes. Answer is yes. Where it was held? It was held in the case of Shri Abhilash Vinod Kumar Jain case. I believe the section number 452 is clear to each one of you. Then section number 301. This section is important for companies who are under winding up. Section 301 deals with arrest of a person trying to leave India or abscond. So section 301 says, at any time, either before or after passing a winding up order, at any time, either before or after passing a winding up order. If the NCLT is satisfied that a contributory or a person having property, accounts, or papers of the company in his possession is about to leave India or otherwise to abscond or remove or conceal any of his property for the purpose of evading payment of calls or of avoiding examination in respect of the affairs of the company, then NCLT may cause the contributory to be detained until such time as NCLT may order, and his books and papers and property which is movable to be seized and safely kept until such time as NCLT may order. So meaning thereby, if the company is under winding up, then NCLT may before passing of winding up order or after passing of winding up order, as the case may be, is of the view that the contributory may flee away, or the person who can contribute to liquidation estate may flee away. In that very case, NCLT may pass detention order, and NCLT may also pass seizure order. But this order can be passed by NCLT once it is satisfied that these person may flee away or may remove or conceal the property. And this order can be passed by NCLT when the company is under winding up, and this NC order can be passed either before or after the passing of winding up order. So what you need to remember, if I come to a most basic line, the most basic line is arrest is different from trial. Arrest is different from trial. Arrest is a stage when you are taken into custody, and this custody is subjected to default bail period, which is given by section number 167 of CRPC. And that is why I was emphasizing consistently that you cannot read Companies Act in isolation. You have to read CRPC in tandem with Companies Act, or I should say, you have to read Companies Act in tandem with CRPC. Next concept, special court. Now, special court is being dealt in section 435 and section 436. Simple provisions only. So, central government by notification has established special courts for the purpose of speedy trial of offense under the Companies Act. Please take a note. By virtue of section number 435, subsection 2, special court is not empowered to deal with the offense as specified in section number 452. So the offense of section 452, that is wrongful withholding of company's property, this very case, this very offense regarding wrongful withholding of company's property by the employees or officers of the company is not in the jurisdiction of special court. The special court has no powers. Special court has no powers to deal with the offense as mentioned in section number 452. The rest other offenses can be dealt by special court, but there are certain caveats. What are the caveats? Special court shall have single judge, metropolitan magistrate, or judicial magistrate of first class, who shall be appointed by central government with the concurrence of Chief Justice of Jurisdictional High Court. The single judge who is holding office as sessions judge or additional session judge shall be dealing with speedy trial of offense under this act, which involves more than equal to 2 years of imprisonment. Meaning thereby, if any offense is committed under the Companies Act, which involves imprisonment of at least 2 years, then these offenses shall be heard and dealt by whom? By the single judge who is holding office as sessions judge or additional session judge. On the other hand, all the other offenses, that is offenses having imprisonment less than 2 years, they shall be dealt and heard by metropolitan magistrate or judicial magistrate of first class. Detention of the accused can be ordered by judicial magistrate for up to 15 days and executive magistrate for up to 7 days. The cognizance of offense by this special court can be taken either on the police report or on the written complaint. What is the written complaint? Written complaint means section number 439. Written complaint means section number 439. But now what happened? One of the customer of the company approached the police station. That the company is not paying me the promised goods and services. In such a case against the company may be lodged at the police station by filing FIR, And in that very case, even police report could be used for the purpose of cognizance of offense under Companies Act. So what do you need to remember? Trial of other offenses under CRPC also allowed, meaning thereby Companies Act is not a substitute. Companies Act is not a substitute for Indian Penal Code and CRPC. So if somebody files a complaint under Indian Penal Code for breach of trust against the company, for cheating against the company under IPC, in that very case, the police report could also be useful. Summary trial is possible if imprisonment up to 3 years. Summary trial is possible if imprisonment up to 3 years. For summary trial provisions, you can refer section 260 of CRPC. In case of any conviction in summary trial, no sentence of imprisonment for a term exceeding 1 year shall be passed. So in summary trial, imprisonment can be granted for up to 1 year only. Appeal against the order of special court shall always lie before High Court. Why High Court? Because special courts are established under the jurisdiction of High Court only. I have a small question for you. The question is, RST Private Limited took money from the customers for selling the apartments to be constructed by it. The company delayed the construction and used the money for other projects. The apartment buyer approached the police station for lodging FIR under IPC for cheating case. Question: will he succeed? Because under section 439 of the Companies Act, court will take cognizance only on written complaint by specified agreed parties. Yes, any answer? Any answer? He will succeed because the complaint is filed for an offense under IPC and not for an offense under the Companies Act. So even, you should be always vigilant that you should not always say that I have a defense because I'm running a company. No, IPC provisions are separate, company law provisions are separate. So if somebody files a case against you or your company under Indian Penal Code, then Companies Act will not be of that much help. And you cannot avail the, liberty of section 439. In that very case, the complainant will succeed. So this is it from my side. I will be discussing with you. You can note my phone number also. Should you have any queries, you are most welcome to ask at a later stage as well. I'm sharing the PPT. I'm sharing the MCQs, and I would request each one of you to answer those MCQs to the best of your understanding. Just give me one moment. I will just share. Just one moment, please. So Raviji, my screen is visible?
Yes, sir. Yes, sir.
Okay. Okay, let me enlarge it. So I believe each one of the participants is already having MCQs.
Yes.
If you don't have MCQs, you can refer my screen. This will be also helpful. So this is question number 1.
Shall I read, sir?
Shall I read the question?
No problem.
Or the people are having answers? Okay, let me read the questions. So the question is, just give me a moment. The tribunal may cause detention of contributory either before or after passing a winding up order in the following cases. He is about to leave India or otherwise abscond. He is about to remove or conceal any of his property. Either A or B, none of the above. What is the correct answer? So this will be the correct answer. Either E or B. This is nothing but section number 301. Section number 301 says this thing. Next question. The contributory was likely to remove or conceal any of his property for the purpose of evading payment of calls or of avoiding examination respecting the affairs of the company under winding up. Accordingly, the tribunal may cause the contributory to be detained until such time as the tribunal may order. Number B, his books and papers and movable property to be seized. Options number C, both A and B, either A or B. So tribunal has the powers to do both A and B. Again, nothing but section number 301. Number third question. No person accused of any offense under section 447 shall be released on bail or on his bond unless, as the case may be, the public prosecutor has been given an opportunity to oppose the application for such release. Where the public prosecutor opposes the application, the court is satisfied that there are reasonable grounds for believing that he is not guilty of such offense and he is not likely to commit any offense while on bail. Number C, a person who is under the age of 16 years or is a woman or is sick or infirm may be released on bail if special court so directs. All of the above. So correct answer is all of the above. Where it is written, section number 212. Every person arrested under section 212, subsection 8 shall within 24 hours be taken to a special court, judicial magistrate, or a metropolitan magistrate, any of the above as the case may be having jurisdiction. So correct answer is number D. Where it is written, Arrest Rules 2017. Number 5, which of the following offenses are punishable under section 447? Willfully furnishing any false or incorrect particulars of any information or suppressing any material information with respect to registration of the company. Number B, willfully furnishing any false or incorrect information or knowingly suppressing any material information with respect to registration of charges. And number C, issuing duplicate certificate of shares with the intent to defraud. And number D, all of the above. So this is nothing but all of the above. This is written in section 7. This is written in section number 86. And this is written in section number 86. So I believe these MCQs are also clear. So Rabiji, this is it from my side. If people have any queries, you are most welcome to ask.
Yeah, any member want to ask something, they can raise the hand. I will make them as panelists. I think none of the members raised. So, sir, I take this opportunity to thank you very much on behalf of Hyderabad branch of SIRC of ICI and all the members who attended. My sincere thanks to Deepak Ladda, chairman of the branch, for arranging this wonderful and excellent session. I thank all the members also who attended personally and who are seeing in YouTube. Now I request branch to share virtual memento. Santosh. Sir, once again, thank you very much, sir.
Pleasure, sir.
You're always.
So whether this memento I will get via WhatsApp or email?
Yes. No, both, sir. Email also and even physical also will send.
Okay.
Thank you so much, sir.
Thank you, Raviji. Thank you very much.
Thank you, sir. Sir, members, this is for today. We request you to please register for the third program of Jamanjar, sir, past shares chairman and Companies Act again. With this, I take leave, sir. Thank you so
I
much.
think some queries there in Q&A session.
I think only one.
Thanks, sir. Thanks for
the
wonderful
wonderful session.
My pleasure, sir. My pleasure.
It's very really very wonderful, sir. You have taken to all the acts and very beautifully presented. Really, from the bottom of my heart, I am